So prenups and postnups have a tremendous impact on asset division. These agreements, if signed without duress, without fraud, freely and with knowledge by either party, then these can have a tremendous impact on how the divorce court is going to handle both issues of marital property, non-marital property, and the distribution of marital property. So if one hopes that the outcome of property distribution is going to be predictable at the time of divorce, then the premarital agreement ideally is the way to go, because they're more likely to be honored, given that they're done prior to the marriage being entered into. And if after the marriage, a postmarital agreement, regularly they are honored, even though they're given a little less authority than the premarital agreement. They can be very effective at preserving one's assets in the moment of divorce. So a prenup can be challenged or set aside in the event that there was duress or fraud. For example, the party who's trying to protect their assets does not disclose the true value of the assets, or does not share the true nature of those assets with the other side. Or there's duress, which is a situation in which one party feels compelled or forced to sign an agreement and did not have, for example, private counsel. One of the ways that we ensure that a premarital agreement is most likely to be enforced by the court is we ensure that each party has their own lawyer who explains to them the consequences of the premarital agreement and explains to them their rights, that they do not have to sign this, and what the ultimate consequences of executing a premarital agreement are. Where both parties have counsel, sometimes even we video the whole process to make it very clear and to have all the proof that everybody was in agreement, then the premarital agreement is extremely likely to be enforced. So the answer to this question of whether spouses can resolve asset division through mediation instead of litigation is yes and no. Yes, they can resolve these issues at mediation, but in order for a divorce to occur, there has to be a court case. So always in the mediation process, there's going to be a court case that surrounds it. So it's necessary to have representation, both to file the divorce, to end the divorce, resolve the divorce, and also to advocate for your rights in the mediation process, because a mediator is going to go based upon what is likely to happen in court at the end of the case, and one wants to make sure that that they understand what their rights are, that they have the attorney protecting their own specific interests in the case, and that it's not just based upon what the mediator might recommend, because there could be a bias, conscious or unconscious, on the part of the mediator. Spouses can't agree on how to divide assets, then ultimately there will be a trial. At this trial, various financial, sometimes forensic experts will give their testimony. All of the documentary evidence that's relevant will be presented, and the judge will make a decision. All these different processes that lead up to this final event, whether it's mediation, whether it's negotiations, a four-way conference, ultimately, if none of these are successful, then the judge will make a decision at the end. There will be a pretrial conference at which the judge will give a recommendation for settlement that either party can accept or reject prior to trial. And at trial, all the evidence will be presented. The witnesses will testify. The parties will testify. The attorneys will have a right to cross-examine either witness, and the judge will ultimately come up with a decision and resolve every issue with regard to property that exists in the case.